Have you been looking for resources to help you navigate contracts in your online business? If so, join the Contract Collective waitlist. The Contract Collective is a membership for online creators and entrepreneurs that equips you with all the tools you need to protect your business and intellectual property with legally sound contracts and confidently negotiate your worth. When you join, you'll gain access to pre-made contract playbooks for negotiations, plug-and-play legal clause banks, a bundle of must-have contract templates, weekly Q&A office hours with me, and so much more. Join the waitlist today to be the first to know when doors open early April. The link to join is in the show notes. You're listening to the Contract Playbook, your on-the-go resource for tackling contracts in your online creator business. I'm your host, attorney Casey Handy Smith. Let's get into it. Hello, and welcome to this week's episode of the Contract Playbook podcast. If you've been listening to the podcast for the past few episodes, you know we talk a lot about intellectual property on this show, and for good reason. As an online creator and entrepreneur, IP is your most valuable asset. Now, if you're not sure what exactly IP is, and when I say IP, I'm referring to intellectual property. So if you're not 100% sure what IP is and you want to get a basic understanding, I recommend that you go back to episode 4 of the podcast. In episode 4 is where I break down what intellectual property is, what type of IP is typically created under contracts, and how to protect your IP with contracts. So go back to episode 4 to get that basic foundational information on IP in contracts. Because today, I want to go over some IP basics for content creators specifically. And when I talk about content creators, whether you're a full-time creator or you're an online entrepreneur who creates content to sell your products and services, and maybe you're brand deal curious, you're thinking about doing content creation for brands, no matter where you fall on that spectrum, the information that I'm sharing with you in today's episode will apply to you. So in this episode, I specifically want to look at what the most important contract is that you need to protect your IP during the content creation process, and how to protect and leverage your IP when you're working with brands. So let's go ahead and dive in to what that most important contract is. If you've been in my sphere of the internet for any amount of time, 9 times out of 10, you have heard me mention or talk about in some capacity a work-for-hire agreement. A work-for-hire agreement is single-handedly the most important contract that you need to protect your IP during the content creation process. Now, what is a work-for-hire? So a work-for-hire agreement simply transfers intellectual property ownership rights to someone other than the original author or creator. Now, taking a quick step back, under U.S. copyright law, once you create something, you own it. So anyone who has created some original work of authorship is the copyright owner. So in the context of content creation, this would apply to photographers, videographers, graphic designers, anyone who is creating content as a part of that process. And so under U.S. copyright law, because your photographer, or videographer, or graphic designer is the one who has initially created that original work, they would be the legal owner of that. And so a work-for-hire agreement ensures that your business becomes the legal owner of that content instead. So that work-for-hire will actually transfer the intellectual property ownership rights over to your business. Now, the reason why this is so important is because you don't want issues down the road where you may become liable for any infringement claims from your contractors. And if you are working with brands, or you're deciding or thinking about working with brands as a content creator, you don't want to be in breach of your contract with the brand, because every brand collaboration contract is going to ask you to make what's called a representation and warranty that you are the legal owner of the content that you're creating for their campaign, meaning there is no outside party, no additional party who can come back later and say that they own some rights to content that is a part of that campaign. Trust me, this can get very sticky for you if you do not have those ownership rights and someone comes up later. It's going to be a big mess for you with the brand. Again, it would mean you have now breached that contract with the brand. You're going to owe quite a bit of damages to the brand for this sort of thing. So you want to make sure that you actually are the legal owner of the things that are created during that content creation process. And how you do this is with a work for hire agreement. Now, I do want to add a quick caveat here to say that when working with photographers, they may not be willing to give you full ownership of the image. But if that's the case, be sure that you still have a clear contract with the photographer that grants you necessary rights to use the content how you need to. So whether that's within your own business or that is with you working with brands. So making sure that you have that clearly outlined in a contract. The work for hire is going to be the most ideal because, again, that transfers legal ownership of the IP over to your company. And so you can maneuver and do what you need to do with it. But if you can't get that, specifically with photographers, that's where it can get a little tricky. So if you have that situation with a photographer, just make sure that you do have a clear contract that grants you the rights that you need. Now, if you are curious on, where do I find a work for hire agreement, like what kind of language needs to be included in that type of contract, we do have a work for hire template at Boss Contract Society, our contract template store. And so I'll be sure to link that in the show notes for you so that you can go ahead and grab that template and have all the legal protections you need and not be out here trying to DIY and create your own agreements. Because as I always say, if you've been listening to the podcast, a poorly written contract can be just as bad, if not worse, than not having a contract at all. So I'll make sure to share the link to that work for hire agreement template directly in the show notes so that you guys can grab it. Okay. Now that we have kind of an understanding of the most important contract you need to protect your IP in that content creation process, I now want to take a look at how to protect and leverage your IP when you are working with brands. And when I say working with brands, I'm talking specifically about influencer marketing campaigns. So you have been hired by a brand to create content for a marketing campaign for them to, utilize in a number of different ways. So that's what we're talking about, specifically influencer marketing campaigns. And the key to effectively negotiating with brands and ensuring that your IP is protected and you're getting paid what you deserve is through usage. Now, if you've been in the influencer marketing industry for any period of time, or even if you are just brand deal curious and you've done a little bit of research, 9 times out of 10, you've seen the term usage pop up. Usage is a heavily negotiated term in any brand deal, and that's because usage deals with intellectual property. For the most simplistic definitions possible of usage simply refers to the ways that a brand can use your content and your image. So that's what usage is. That's what we're talking about when we talk about usage. Now, before you can really take a look at, negotiating usage and how to really leverage it in working with brands, it is important that you understand what your rights are as a content creator. So the influencer marketing industry is pretty unique from the standpoint that influencers and creators typically own the content that they create. And I say that this is unique because if you look at traditional media outlets like commercials, it's just the opposite. The brand would own the content. They'd own your image, like hands down, no questions asked. But the influencer marketing industry actually allows you as a content creator to own your content, which is wonderful. It definitely gives you an upper hand in negotiations, but that also means that usage, is heavily negotiated in these contracts because it deals with that IP where in other platforms, a brand may already own it. And that's not to say that a brand may not try to own your IP. So if that's the case, make sure you're being on the lookout for things like a work for hire provision, like we just talked about, inside of a brand deal, because those do pop up in brand deals as well, where essentially they're saying, hey, I know that you're the content creator, and because you're creating it, you legally would own it under US copyright law, but we want you to transfer these rights over to us as a work for hire. Something like this is typically a major red flag in influencer brand deals, and you don't want to agree to that. So make sure you're being on the lookout for that. But most cases, you're going to actually be negotiating usage because you're going to own your content under these types of agreements. So a couple of things to keep in mind when it comes to best practices for negotiating usage. You're going to be looking at two components of it. You're going to look at the scope of the usage and the length of the usage. Now, when we talk about scope of usage, you want to make sure that the contract clearly states and is specific and limited to the types of platforms that the content will live on. So this means paying really close attention to terms like all forms of media or all digital media use, because the online space and social media platforms are constantly changing, which presents greater opportunities of brand reach in a campaign, which is great in terms of reach. But as a creator, you want to make sure that you're adequately being compensated for that reach, whether it's going to be organic usage, paid advertising, or even whitelisting of your usage. So you want to make sure that the scope of the usage is very specific as to, again, the types of media and the specific social media platforms. And now the second component here is that length of usage. Talk about other hot button topics and influencer brand deals in perpetuity. So if you've done any research or have worked in this space at all, you know that in perpetuity is another one of those red flags. And in perpetuity simply means forever. They want to have access to your usage and your content and your image forever. And we don't want to do that because, again, as a creator, you want to be adequately compensated for your content and for the usage of your content so that you can, utilize it in other ways, other spaces, other platforms, outside of digital media and things like that. So you want to make sure that you have a clearly defined length of time with your usage as well. Now, of course, this will vary from contract to contract. It really depends on the goals of the brand. It depends on your goals. Is this a short-term partnership, a longer-term partnership, the cost of, the contract itself? So these things are going to come into play quite a bit in every contract. And so overall, definitely expect to spend some time negotiating usage because brands expect it. And they're typically willing to work with you and get creative if they really, really want to hire you for a campaign and they really want to work for you. So just to kind of quickly recap what we've talked about in this episode, it's important that you own the IP that's created during that content creation process, via that work for hire agreement that we talked about. So that's kind of that first layer, is making sure you actually own the IP that's created. And again, I'll have the link to the work for hire agreement template in the show notes. And the second thing here is that you understand what your rights are as a creator and that you implement these best practices we've talked about when negotiating usage in your brand deals. Now, if you want to go a bit deeper to this topic, especially on the brand deal side, next Tuesday, I'm going to be hosting a free webinar where I'll go into more depth and detail about how to negotiate mutually beneficial brand partnerships without necessarily needing to hire a lawyer. And in that free training, I'll dive deeper into usage and other key terms like exclusivity, some of that other fun legal jargon that pops up and can trip you up in negotiations. And I'll also be sharing my 3-step redlining process for negotiating brand deals that get you paid more and ensure your rights as a creator are always protected. So the link to register for this free webinar will also be in the show notes. So if you're interested in that, you can go and register for that now. Again, that's next Tuesday, and you can go and register for it using the link in the show notes. So I hope, as always, that this was helpful for you. And if it was, please be sure to share this with a friend, leave us a review, and connect with me on Instagram over at Contract Casey. I would love to hear from you and know your biggest takeaways from today's episode of the podcast. Thank you so much for tuning in, and I'll talk to you in the next episode.